Hey there, this is Pat Ennis of Ennis Legacy Partners. Welcome to the Exit Readiness Podcast. I'm here with my co-host Walter Dial, CPA and tax partner here at Gelman, Rosenberg & Friedman in Bethesda, Maryland. Our mission here on the Exit Readiness Podcast is to provide you, the business owner, with subject matter expertise on topics pertaining to building sellable or transferable business value and for planning your eventual exit from the business. We want to help you exit your business successfully and on your own terms and conditions. Walter, we often say business owners cannot do exit planning without doing estate planning, and they cannot do estate planning without doing exit planning. What is some of the common estate planning problems or issues you've observed in your practice through the years upon the death of a business owner client?
Well, I think two things really come to mind, Pat. First is just the basic decision. Is it going to make sense to keep the business or to sell the business? And that really should be decided well ahead of time, as we'll be discussing today. The other issue is, if you decide to keep the business, how do you make your estate distributions fair, given the fact that you may have multiple children, some in the business and some outside of the business? So it can get pretty complicated.
Well, it can get complicated, and another key consideration is the continuity of the business. If an owner passes away suddenly or unexpectedly, and the family is dependent upon the value of that business one way or the other, the family that the owner leaves behind, what's going to be most conducive from an estate planning and legal perspective that can be put in place? What tools can be put in place ahead of time to help facilitate that business continuity so that the business continues without losing value? That's another key issue. And so today, as a result of today's podcast, listeners, you're going to be better equipped to address these critical issues now, well ahead of time. Our topic is specifically the use of a trust in transferring ownership of your business at death. And our guest today is Micah Bonaviri. Micah is a partner in the estate planning practice at Stein Sperling, headquartered here in Montgomery County, Maryland. Micah's University of Texas at Austin graduate, BA from there, Suffolk University Law School. He's got a JD from Suffolk University Law School. Georgetown University Law. He's got an LLM, taxation, estate planning. His profile, Micah's profile, if you go to Stein Sperling's website, says this: with his relaxed, engaging nature, Micah Bonaviri has a natural ability to make his clients feel comfortable with trust and estate planning, often being an emotional and complex topic. Micah recognizes that for many clients, the underlying concern is for their loved ones' financial and general well-being. Micah seeks to put his clients at ease by actively listening to their goals, enabling him to develop creative estate plans in a clear and efficient manner. And I just want to say I can confirm this to be the case about Micah. As I was telling you before the call, Walter, recently we share a client relationship. And this written profile on the website about Micah is exactly how Micah operates in a real-life client situation. He put my client very much at ease, relaxed. And, this is not easy stuff to talk about for anyone, estate planning. So I'm really excited to have him here today. He's not only a relaxed and engaging guy, though. He's also very competent and knowledgeable in planning areas of asset protection, business succession, guardianships, charitable gift planning techniques, trust, and estate administration. So, Micah, welcome to the podcast. Great to have you with us today.
Yeah, great to be here. Pat and Walter, thanks for having me on, and I look forward to the discussion.
Well, Micah, thanks for joining us. Let's go ahead and jump right in. So what do you see as the most important estate planning issue that a business owner faces that perhaps a non-business owner wouldn't be facing?
Yeah, I think to your point, which you mentioned earlier, really the biggest concern is what happens next. So right now, when business owners come in and they think they want to do estate planning, or maybe someone has encouraged them to do it, they never really thought about what type of succession plan. Oftentimes, they may not even have an operating agreement. They may not have even thought about, well, if something happens to me, if I become incapacitated, or if I pass away as a business owner, what's going to happen to the business? And, with their other assets, things like a house, bank accounts, things like that, in their minds, they may think, okay, well, that's easy. That'll go to a spouse or two children or family, friends, charities, whatever it may be. But with a business, it's really different. And there has to be a plan in place. As you said, do you want to liquidate the business when you pass away? Do you want to continue to operate it? Do you want your family to operate it? Which family members? If we have one child who's involved in the business and one or two that aren't, how do we want to handle that? How do we want to treat them equally? Do we want to give one some sort of compensation or additional business interest for being involved in the business? All of these types of questions really need to be answered. Otherwise, you're really handcuffing the family.
Yeah, and so Micah, let's keep in mind the current client situation that you and I are working on together. And one of the reasons that I introduced this client to you to begin with was I was wondering, as I often do, is kind of my common practice particularly with a sole owner, whether or not it would benefit the owner's heirs, decedents in estate, if they indeed placed their business interest in a trust. And again, having this whole category or issue of business continuity in mind. And so what would you say to our listeners are some of the key factors in deciding whether or not to place a business interest in a trust?
So it's a really good question, and it happens to be a hot topic right now too, because it really addresses the connection between estate planning and business succession planning. And just by way of a little background information, the use of a trust, setting up a trust, is a vehicle to administer the business interests. So, as an example, let's say that I owned my own small family business, and let's say it's a dry cleaning business, and I want to come up with a way to pass along control. I want to plan for, if I become incapacitated, who's going to have the authority to run the business, and ultimately I want to be able to say what's going to happen to it, when I become incapacitated or when I pass away. And so if I were to create a trust and then transfer my ownership interests in this dry cleaning business to the trust, then I, as Micah Bonaviri, am no longer the individual owner, but the trust becomes the owner. And usually we make the trust revocable, which means that it can always be changed. And we make me the initial trustee, the person who's going to be in charge of the trust of the dry cleaning business. So really, from a practical point of view, nothing changes. I'm still in complete control. I can still sell the business. I can still do everything that I could have done before. However, it creates this really easy and useful way where I can dictate what's going to happen if I can no longer do it or I no longer want to do it. And so I'm able to name who would be the successor trustee, who could actually run the business. They wouldn't need to go to court and get appointed. We keep court involvement completely out. We eliminate any family disagreements. If there are two kids, which one gets to control? I actually get to dictate all of that. And then I get to, in the actual trust, I tell them what is going to happen. Are we going to liquidate? Are we going to continue it? Who's going to own the shares? All of that type of stuff. So with that in mind, that's sort of the backdrop. Then the question does become, well, when would we want to do that? What are some of the considerations? Would this dry cleaning business actually benefit being owned by a trust? And I really think it comes down to two big components. So the first one is avoiding probate. And that's sort of the probate process when someone passes away. There's all of these deadlines and items that need to be done with the court system or with the register of wills where the person passes away. So by putting it in the trust, the first thing we do is we simplify that. We make the jobs of our family members and our friends much easier if I were to pass away. But really, the key here is, do we want to handle the ownership and the management of the business differently than all of my other assets? So going back to what we said before, if I want my house and my bank accounts and my cars and all of those types of things to go to my spouse, then I could do that in my own will or through joint ownership of the properties. But if I want the business to go pass differently, let's say that instead of having my wife have complete control, I want one of my kids to run it, or I want, someone who's currently in management in the business, a key employee, to continue to run it. Then I might want to put it in this separate trust to really create this, these different vehicles and this separation of assets so that it can be handled differently. I could still have my spouse and my kids be beneficiaries of the trust, but it really allows me the control to determine who's going to run it, how they're going to run it, and what's going to happen.
So what situations can you think of where an owner would not consider putting their business interest in a trust?
I think there are a couple. So first of all, we need to look at what is the type of business. So there are types of businesses that cannot be owned by a trust. For example, many of state laws, prohibit dental practices from being owned by a trust. It has to be owned by an individual who's licensed, things like that. If you want to put it into a trust, then maybe you have to get approval from the board in that state. So that's number one. We need to make sure that the business can actually be owned by a trust. Number two is, if it's the type of situation where upon death, someone just wants the business, or even upon incapacity, they just want the business to be liquidated. They have no intention of it running at all after them. For example, if they are the business, if it's a one-man shop where they are 100% owner and really they are the goodwill, there's really nothing else without them, then in that situation, we might not need to put it in a trust because we could spell out in their will exactly what would happen. It would just basically be sold to the extent there is any value, or realistically the assets that it owned, if any, would just be sold off, and then the proceeds would just be distributed along with their remaining assets when they pass away or in the event they're incapacitated. So I think that that's the biggest situation where we see that, the use of a separate, standalone, single-purpose trust may not even be necessary.
Mistakes that business owners make. So, Mike, I'm sure you've seen lots of mistakes that business owners make in this regard. I know one I've seen a couple times with new clients is where they come in and they're an S corp and they have a trust that owns the S corp stock, but it's not a qualified S corporation trust. And we've had to jump through some hoops to clean all that up. Are there some other common mistakes that you see?
Yeah, I mean, that's one of the big ones where, the trust itself cannot own the S corporate shares, and it actually ends up disqualifying it or losing the S status. That can become a real challenge. There are definitely a couple others where, they may not have thought through, who would be the successor trustees, and maybe they have a key employee that they want to do it, but it would have actually worked better if they may have had some sort of committee of trustees. I know that that can get cumbersome, but sometimes it makes sense to have a spouse and a key employee as successor trustees so that the spouse can obviously have some input into what happens, how much the business sells for, things like that. But from a practical perspective, the spouse may know very little about the business, and so we might need, a key employee or a good friend or a partner to have some sort of involvement, at least administratively as well. So picking the proper successor trustees is huge. Things like the other big one is the distribution upon death. Going back to, what if we have one child that's really involved in the business, but then the other one or the other two are not? Maybe the client still wants to treat them all equally from a financial perspective, but in terms of administration, maybe they want that one other child who's involved in the business to have more of a say and to really control what happens. Then we start getting into, well, can we create voting and non-voting shares? In other words, we give the other two kids an economic interest in, so if the business does well, they get to reap the benefits financially just as the other child, but we let the other child really dictate with all of the voting rights what's going to happen. So when that is not addressed in advance, that often leads to a lot of problems as well.
Yeah, that makes sense.
Micah, what are some of the other documents, if you could review with our listeners for a business owner, other than a trust, and a trust, again, may or may not be the right strategy or tool for any given. If you're a dentist, it's not going to be, but for a lot of situations, the trust document will be and tool will be applicable. What are other documents, legal, estate planning documents, that are normal or typical when it comes to estate planning for a business owner?
So I think, first of all, the way I like to view it is you got to have your primary or foundational documents in place. So that would be, your will, your financial power of attorney, which says, if I become incapacitated, this is who can step into my shoes and pay my bills, sign my tax returns. Some people even take the approach of, we want to have one person being power of attorney over everything other than the business. So some people have two powers of attorney. I generally prefer to have one power of attorney to handle all of the other assets and then put the business in the trust. I just think it's cleaner and simpler. But if we can't put the business in the trust, then the use of a power of attorney obviously becomes very important, because that person is going to be the one who can step into your shoes and run the business if you can't. Obviously, we need a medical directive and a HIPAA authorization so that people can handle your, medical decisions if you're unable to. And then once we get those foundational documents in place, then from the business perspective, we need to have a few things. We want to have an operating agreement that sort of dictates the relationship among the owners, if it's an LLC, among the members, who's the managing member, who's in charge, what happens if the business is sold, how do we divvy up the proceeds. It really spells out all of these types of things amongst the members. And we may need something called a buy-sell agreement, which says that if one member or one partner wants to exit the business, then we need a way to buy, or if they pass away, we need a way to purchase those business interests, because maybe we don't want that person's spouse or children to become members, or maybe they're prohibited from becoming members. So we need a way to actually buy out those shares, so the company has them, and we may not admit that a new family member as a new member. So oftentimes that's done through life insurance and things like that, and other types of insurance. Um, the One of the big things that we see people often forgetting is they may set up a single purpose trust, for that dry cleaning business that I mentioned, and then have all of the intention in the world of having that trust really own and administer those interests in the dry cleaning business, but they may forget to transfer ownership. That's the last step. Is I would need to assign the ownership from Micah to, the dry cleaning trust. And it's really simple. It's 1 or 2 pages, but it's really important because there are two big concerns. One is we need to make sure that the operating agreement allows the transfer to a revocable trust. So not only does the state need to authorize it, but the business needs to have said, hey, you know what? We're going to allow you to transfer your interest to a spouse, to a family member, to any of the other members, and to even a revocable trust if you want to for estate planning purposes. So we need to make sure that that the interest can be transferred and that it is, but then also, what are we transferring? Are we just transferring the economic rights, either to a trust or to a person, or are we also transferring the voting rights? And so it's really important that that assignment spells that out, because we want to avoid litigation down the line. So I think those are some of the bigger documents that are obviously needed.
Mm-hmm. Yeah, you mentioned buy-sell agreements a few minutes ago. Sometimes the buy-sell agreement, if there's one in place, can be a part of the operating agreement, and sometimes it's a separate document. When do you recommend that it be a separate document apart from the operating agreement?
Well, two things. In that situation, oftentimes I'd want to get you involved and really get your perspective on it, because most of the time where we're seeing it is that people are coming in without operating agreements, and so we end up doing both at the same time. Otherwise, they may come in with just an operating agreement and then need to do the buy-sell agreement. So to the extent we can, we often try to do them both at the same time. But sometimes, people aren't ready to do that, or they're not forward thinking that much. Maybe there's a situation where at that time, there's no need. They're not contemplating having to buy out one of the members. So they don't even think about doing the buy-sell agreement or needing to do the buy-sell agreement from the beginning, because maybe if someone were to pass away, maybe they're allowed to transfer their business ownership interest to another member or to a spouse or something like that, and it doesn't need to be bought back immediately.
So, Mike, I think there's kind of a general rule for estate planning where, we kind of tell clients, if your estate plan is all set, you really only need to revisit it when there's either a change in the law or, a serious change in the family situation, maybe a divorce or a new beneficiary or a beneficiary dies, something like that. But it seems like with a business owner, they really need to be visiting their estate plan a little more often. I think there's a lot of different moving parts with the business that can impact their estate plan. So how often do you suggest that a business owner revisit their estate plan?
Yeah, no, I think it's a really good question, and there is a distinction. So generally, what I suggest with clients is that they want to take a good review of their overall estate plan every 4 to 5 years, let's say. And it goes back to what you were saying would be changes in the law, changes in their personal circumstances, things like that. But when we talk about a business owner, my suggestion is I always encourage them to maybe revisit things every 2 to 3 years. Pick up the phone, call Pat, call, your estate planning attorney or your business attorney, and call you, Walter, call your CPA, get these people involved and say, you know what, these are some of the things that have changed. I had a key employee, that person left. We did or we didn't do things like non-compete clauses and things like that. Or now since we set this up, now one of my kids is involved a lot more, things like that, which will lead to tweaks and in the overall plan, especially from the business perspective. So I always recommend, you pick up the phone, have a 20-30 minute conversation every 2 to 3 years, just to make sure that things are still in line and that your wishes are still sort of, going to occur and the way you want them to occur.
That makes sense.
Okay, so Micah, as we wrap up, what should we be asking you about the use of trust with business owners in estate planning that we haven't asked you so far? And then any last words of wisdom or suggestions for next steps?
Yeah. So first, in terms of business owners, the real question is, first of all, are they contemplating some sort of sale or a liquidation event? Do they have any interest in selling the business anytime soon? If they do, then they may want to meet, with you and with a business attorney who can help facilitate that sale. If they plan to continue to operate it, then that's when we really want to dig in and determine whether or not a trust is appropriate. And that really depends on who the primary members are that are going to be involved in that, and what do they want to happen. Do they want it just to be liquidated if they become permanently incapacitated or pass away, or is it their intention that it be continued either by the people that are currently involved in the business or by family members or whoever it may be? So those are some of the types of questions. Obviously, the value of the business really helps sort of guide things as well, or drive things, because we need to make sure from an estate tax perspective that we can at least minimize everything or even eliminate taxes to the extent possible. In terms of wisdom or suggestions, I think a couple different things here. So first is, remember that when you sit down with an estate planning attorney, or generally any attorney, that a business succession planning attorney, they're not just document drafters, right? So I always like to joke, although I'm serious, is that I'm not a will drafter. If you're looking for someone to come in and sit down with and just do exactly what you say and not really think about any of the moving parts, then that's probably, you're not meeting with an estate planning attorney. We like to plan. And so lots of that makes, we encourage the clients to be involved and to keep that in mind, because I always joke, you either spend money up front or you spend a lot more money, your estate or your trust spends a lot more money on the back end. So keep in mind that law firms, they make a lot more money when there's mistakes and things aren't thought through, because it leads to delays and it leads to more expensive. So I always encourage people to do the planning up front, try to get it done sooner rather than later. It'll save money on the back end. And the other thing is unfortunately right now is we live in a pretty litigious society. And unfortunately, as a firm, we're seeing lots and lots of estate litigation. And it can be anything from a second marriage where the new spouse and the kids from a prior marriage are fighting. It can be a situation where siblings are fighting when people pass away, not only who's in charge and running things and what types of fees they're getting, but how the assets get distributed. We see situations where the intention is to treat both kids equally, but by not handling it correctly, one of the kids ends up with a lot more assets, or assets that are much more valuable, like a business, than the other child. So it's things like that. Is we want to plan. The real thing is we want to plan ahead, and it is the plan that's important. It's not just coming in and getting your will done and your powers of attorney. It's really coordinating everything and getting a plan in place.
Thanks, Micah. This has been really good. So, Pat, what do you think some of the key takeaways for our listeners are?
Yeah, well, 2 to 3 years. If you're an owner, you've been listening to this podcast and you haven't taken a look at your estate plan with your estate planning attorney within the last 2 or 3 years, I would just I think we'd strongly advise you do that. And as you when you do have that conversation, ask them about, with the use of a trust, if indeed you don't have a trust in place currently, to transfer your business at death. Just ask and see if it would make sense for your situation, because it sure might. It might help you help you to avoid probate, of course, and it just may make the whole transfer much easier for everyone else. So do that. And then another thing that occurs to me that really is kind of off topic but very pertinent. Walter, we're always, when we meet with business owner clients and we're talking about putting together a comprehensive exit plan, we stress this. When you build this team of advisors that you're going to need CPA, you're going to need tax help, and you're going to need legal, both estate planning and business law. You want experienced advisors. You want people who understand the world and life of a business owner and transactions, be it internal transactions, external, transfer at death, whatever it is. You want people like Micah on your team who are experienced. So that's a big takeaway, of course, is to make sure that your estate planning attorney is someone who understands business owners in the transition of businesses.
Yeah, I definitely agree with all that. Micah, thanks again. This has been really great. If listeners want to reach you, how do they do that?
Yeah, so I'm located in Rockville, Maryland. My phone number is 301-838-3235. Or I can be reached by email at mbonaviri, so that's M, B as in boy, O-N as in Nancy, A-V-I-R-I, at Stein Sperling, all one word, .com.
Fantastic. Thanks again for joining us, Micah. We really, really enjoyed it.
Thanks for having me.
To begin now in planning your successful exit, check out exitreadiness.com for information on an online exit planning course and the Exit Readiness Base Camp, which is a one-day exit planning workshop for business owners. And if you'd like to speak to either Pat or myself regarding building the value of your business or planning your exit, you can reach Pat at 301-859-0860 or me at 301-951-9090. Until next time on the Exit Readiness Podcast, this is Walter Dial and Pat Ennis signing off.